bazillion-dollar case against the Daily Mail, lost on all 97 counts, and now it seems like he kind of knew. This seems like they're in a lot of hot water, but also the judge, Justice Nicklin, is furious.
30 million from Diana, gone.
And you know that you've got him on the hook here. You really have put him on the hook and squirming. The potential embarrassment of the discovery process is nuclear. It really is.
Works, they all wind up in bankruptcy.
This is the number that could turn a courtroom defeat into a financial nightmare. 16.2 million. Forget the giant 34 million and 50 million figures being thrown around in headlines for a moment.
What do I expect to happen? I don't think the Mail will get the whole 34.5 million. But I don't think they'll be stuck with the approved costs either. I think it'll be somewhere in between.
Because buried underneath all that noise is a smaller number with a potentially devastating meaning. Prince Harry is approaching a court cost ruling this month, and suddenly the real drama is not simply how enormous the final bill might become, but whether the protection supposedly standing between him and disaster can actually survive it. The figure is 16.2 million, and once you understand what that number represents, the entire situation starts looking very different.
The statement is being used by the Daily Mail. They are saying that the statement sort of shows the bad faith of two of the claimants, Harry and Doreen Lawrence, who put their name to that statement. It's interesting that the other 5 didn't put their name to it, isn't it?
Even more explosive is what his own legal side reportedly put before the High Court in writing, an acknowledgement that under the harshest cost scenario, the available cover might not be enough. That is where this stops looking like another expensive celebrity lawsuit and begins looking like a financial trap closing from several directions at once. There is the immediate costs battle, there is an upfront demand running into millions, and behind it sits another lawsuit carrying another potentially expensive threat. The question is no longer simply who won. The question is what happens when losing becomes more expensive than the safety net designed to absorb it. 97 claims, every one dismissed. On July 7th, a massive 436-page judgment landed against the Duke of Sussex and 6 co-claimants, and there was no comforting partial victory hiding inside it. No technical escape hatch, no reduced consolation prize. The entire package failed. And in an English courtroom, that creates a frightening second act because losing can mean paying the winner's costs. Suddenly, a case presented as a fight for vindication becomes a fight over who was going to absorb an extraordinary legal bill. The publishers claimed costs exceeded 34 million, an amount described as unprecedented for a high court media law case. But even that headline number does not tell you what Prince Harry will ultimately owe, because costs can be challenged, assessed, and dramatically reduced. That uncertainty should sound reassuring. It isn't, because another demand arrives before that detailed process is even finished. More than 9.9 million is being sought up front as an interim payment, a global amount involving all 7 claimants, while the judge is expected to determine what happens next in a written ruling during the week of August 17. And this is exactly where 16.2 million suddenly becomes the number nobody can ignore. The 7 claimants had after the event insurance intended to protect them against the opposing side's costs if the litigation collapsed. Combined cover 16.2 million. On paper, that sounds like an enormous shield. But then came this sentence capable of changing the entire atmosphere. Their own side acknowledged in written submissions that if costs were awarded on the indemnity basis, the current insurance cover could be insufficient, potentially by many millions of pounds. Think about what that means. The warning did not originate with a hostile commentator trying to manufacture drama. It appeared in submissions made on the claimant's behalf. The protection exists, but their own legal argument contemplated a scenario where that protection does not stretch far enough. And now everything turns on 2 words: indemnity basis. Under ordinary costs assessment, reasonableness and proportionality can cut bills heavily. Indemnity costs create a much more dangerous landscape for the losing side. That makes the next question absolutely crucial. Will the court actually go there? Because 16.2 million may look like a fortress against an ordinary reduced bill, yet against costs exceeding 34 million under a tougher assessment, that fortress could suddenly look frighteningly small. And what happened after the judgment may have made that question even more explosive. When the judgment landed, the fallout did not remain politely inside the courtroom. A statement describing the outcome as a complete and obvious obvious whitewash emerged with Prince Harry and Baroness Lawrence attached to it, while Elton John, David Furnish, Sadie Frost, Liz Hurley, and Simon Hughes did not sign. That silence suddenly mattered because the publisher's lawyers later cited the statement while arguing for costs above the standard basis. What had looked like outrage after defeat was now being pulled back into the courtroom as part of the costs battle itself. Senior members of the British judiciary were also reported as criticizing the implications of the statement toward the judge, creating an extraordinary contradiction around a man whose public battles have repeatedly centered on personal security. And because costs are shared severally, there may be no neat escape through separating one claimant's conduct from the wider litigation. Even the reporting involving Chelsea Davy, described as one claim that potentially could have stood differently alone, remained trapped inside the package of 97 claims that failed together. Then comes the question nobody can avoid. Where does the money come from? Reporting surrounding Meghan and Harry painted an increasingly uncomfortable financial picture, including claims that operating expenses connected with the Montecito household require at least $6 million annually. Then came discussion of inherited wealth, $10 million attributed to the Queen Mother, and another $30 million connected to Diana, with commentators claiming that money has disappeared through spending. Add expensive security, clothing, staff, hair and makeup, and the image becomes brutal, enormous costs continuing while new income allegedly struggles to match them. Sources described Meghan and Harry as having assumed millions would continue arriving, effectively spending against a future they believed was guaranteed. But what happens when that future fails to arrive at exactly the moment a court bill does? The business numbers added another uncomfortable clue. Meghan reportedly recorded around 246,000 site visits in December, rising overall to approximately 268,000 in January, yet American traffic reportedly dropped from 108,000 to 89,000. Then there was the awkward resurfacing of an October 2016 comment criticizing a $100 candle as obnoxious, contrasted with candles now reportedly being sold for $262 per set. Meanwhile, another report claimed Prince William and Princess Catherine's Royal Foundation had overtaken Harry and Meghan's Archewell in charitable influence and fundraising momentum in the United States. William and Catherine appeared to be gaining confidence in the very market where the Sussex operation was supposed to flourish. And just when the financial pressure already looked suffocating, another case appeared behind it. A defamation claim against Prince Harry and Mark Dyer was filed in the High Court in March, while the woman bringing that action reportedly confirmed that the charity itself was not funding the litigation without identifying who was. Speculation followed that a wealthy outside backer could potentially be involved, although that remained explicitly framed as a guess. Yet the real danger may not be damages. It may be disclosure. WhatsApps, emails, and texts involving Harry, Mark Dyer, and Meghan could potentially become relevant to the legal process, creating what one commentator described as nuclear embarrassment. The Charity Commission had previously completed an inquiry and found no evidence of bullying, yet the claim followed months later. Now Prince Harry potentially faces one enormous cost battle while another legal fight threatens private communications. That makes royal reconciliation suddenly look less sentimental and more structural. In July, Harry reportedly came alone while the wife and children did not, and the palace publicly clarified it did not know whether the king's invitation had been accepted. Another commentator claimed Harry and the children were given access to King Charles before Meghan, although that account remained single-source rather than established. No photographs emerged, no interview followed. Nothing useful appeared publicly. The bleakest comparison then arrived. Even reconciliation might never mean restoration as a working royal, with Andrew invoked as the possible sealing private family events, but no meaningful return. A meeting with the king therefore becomes incredibly valuable for Harry because royal proximity still carries commercial weight, while William and Catherine reportedly remain unwilling to arrange private meetings outside a possible official public engagement. And beneath every rumor sits the one document that refuses to disappear. The judge has not yet decided indemnity costs, the publisher's estimates could still be reduced, the funding theory remains unproven, and Prince Harry rejects the defamation claim. But his own side acknowledged that $16.2 million of insurance might not cover an indemnity award. 97 claims dismissed, more than $34 million in claimed costs, $9.9 million sought upfront, another lawsuit waiting behind it. The privacy battles we're supposed to protect would remain behind closed doors. Now, the terrifying possibility is that the ultimate price of those battles could be measured not only in money, but in the very privacy they were designed to defend.